Hello viewers, welcome to class today. We are learning government today, and the topic we are looking at today is the arms of government and of course separation of power. Okay, there are three arms of government: the legislature, the executive, and of course the judiciary. Please come along as we go deeper in this topic. What is the legislative arm of government? The legislative arm of government is the body that represents the people, that makes law for the state. The body that speaks on behalf of the people is seen as the mouthpiece of the people. The body that approves public expenditure, the law-making body in any state, is called the legislative arm. We have two types of legislature: unicameral and of course bicameral. When we say unicameral, what are we talking about? We mean a type of legislative arm where there's a single house or single chamber for lawmaking. Having only one house makes the process of the law faster and of course with a simpler structure. Then we have bicameral. Bicameral from the word bi means two chambers or two houses where laws are made. In this case, we are going to have the lower house and of course the upper house. All right? In this case, why must we have two houses? With these two houses, there will be additional scrutiny. There will be enough representation for the people so as to reflect the social interests that make up that society. And with this second chamber too, to help us to check hasty legislation. Okay? Now, typical lawmaking process. There are stages or processes for a law to be made. In fact, the legislature actually proposed bills, and when this bill passes through certain processes or stages, the bills become a law after being assented by the head of state. So for this process, we have the first reading. The first reading or the first stage is the initiation or the introduction of a bill in the House. This bill could be introduced either by a member of the House or a prominent member of a society. It could also be by a minister representing the executive. It could also be by a committee, all right, that is presenting a bill. In this case, there's no detailed debate on the bill. It's just an introductory stage. The second stage or the second reading, there will be a general debate. There will be voting on the principles of that bill. And this voting will be for or against the bill. Okay? And whatever decision of that voting is arrived at will determine the life of the bill, whether to progress or to die. And that's why we agree that the most critical stage of passing a bill into law is the second stage. A bill that survived the second stage from a popular or majority vote moves to the committee stage. The special committee stage set up will do a detailed clause-by-clause examination and amendment to the bill. They will do the investigation, and then they will come to a report stage. At the report stage, the committee will report their findings to the General House, and as such, they will present their recommendations to the House. Now we move to the third reading or the third stage. This is the final debate of voting in the chamber at the floor of the lawmaking house. All right? It's the final stage at the floor. After this stage, if there are two chambers or two houses of lawmaking like we have bicameral, the same stages that we have seen in this first house will also go to the other chamber. If it's bicameral, they will also pass through these stages of first, second, committee, and report and what have you. And after they are done with that in the second chamber, okay, if there are discrepancies or differences between the first and the second house, then there will be a kind of conciliation, if necessary, where they resolve the differences between the two chambers or the two houses, okay? And after these differences have been reconciled, the next thing is that the bill will be sent to the head of state for what they call assent, that is, approval of the bill. And after the head of state must have given assent, signing the bill, then the bill will be promulgated into law. But maybe I should tell you at this point that sometimes the head of state may decide to withdraw the assent using his veto power. If he does that, it means the bill cannot become a law, but he has to give a reason for doing that. All right? And after giving that reasons, the bill will get back to the House. And the House will consider those reasons that the head of state has given for not signing their bill to law. And after considering the bill, considering those reasons, if they are genuine, they will attend to it. But if the House think that the reasons are not sufficient enough for the head of state not to sign the bill to law, they will send the bill back to him and they will advise him to get advices from his advisors and sign the bill to law. But if he insists that I refuse to sign such bill to law, eventually, after about 90 days given to him, the National Assembly or the Legislative House will have a joint sitting, and in that joint sitting, if it's bicameral, 2 houses, they will vote on the bill. And once they vote, 2/3 majority of the votes on that bill supporting the bill turn the bill to law. So whether the head of state signed the bill or not, with 2/3 majority of the House will override the veto of the head of state. Okay, so I hope you understand legislative arm at that point, because at the end of this session, I'm going to have some questions to examine or to test you on whether you actually understand what I'm teaching right now or not. Okay, so let's go on to the second arm of government. Remember I told you earlier that we have 3 arms of government. So let's go to the second one, the executive arm of government. This arm of government is responsible for implementing and administering the law. This arm of government is responsible for the running of day-to-day activities of the government. In fact, many people assume when we hear government, the executive is government. People assume executive as the government. It is only you that has the knowledge of government as a subject. We know that when we mention government, the government is made up of 3 organs: the legislature, the executive, and of course, judiciary. But ordinarily, people who are novice, they see government as the executive, the president, and of course, its ministers. Why? Because they're the ones that have been seen day in, day out, running the activities of government businesses. Okay? So, we have these types of executive arm of government. 1, 0 executive. When we say 0 executive, it means executive authority is not given to any single person, right? No single person at the center exercising that particular executive power. This is very common with international organizations like United Nations, like AU. We have, for instance, for United Nations, we have what they call the Secretary General, who is the symbol, the representative of the flag bearer of the United Nations. Even within the Security Council, the chairmanship is rotated annually, and none of them is exercising what? Executive power. So in this kind of place, whoever is the head in a 0 executive is just a titular head, a figure head. The second one I'm going to examine today is the single executive. In this case, the executive authority concentrated in one person. And this person is known as what? The executive president. And being an executive president means he is both the head of state as well as what? The head of government. Okay. The next type of executive is what they call dual executive. In this one, the executive authority shared by 2 persons. 2 persons share executive powers. This is very common in a parliamentary system of government, okay, where we have the head of state as a ceremonial president, and of course, the head of government as a prime minister, okay. Now, the next one I will identify as a type of executive is plural executive. In this case, the executive authority is shared by a small group or a council, okay. This is very common with Switzerland, where the federal council or system were made up of executive duties distributed among different ministers and committees. This is peculiar, particularly to Switzerland. So remember, I've just mentioned 4 of them: the 0, the single, the dual, and of course, the plural executive as types of executive arm of government. Very well. So what are the key functions of the executive arm of government? We need to know this, okay? They enforce and administer the laws as stated in the explanation, the definition. They formulate and implement policies. Please take note of this. If the word says formulate and implement laws, is correct. But if the law says formulate laws, legislature formulate laws, But executive formulate what? Policies, government policies. They prepare and execute government budgets. They conduct foreign affairs through the Foreign Affairs Ministry. They appoint public officials like ambassadors, like chairman of parastatals, public corporations, and whatever, even ministers. They are all public officials appointed by the executives. They also command the armed forces, and that is why the head of the executive, the president, is seen as what? The commander-in-chief of the armed forces. Also, by the executive, through the president, they grant pardons or clemency, and they also declare emergency administration, like what they call state of emergency. All these are functions of the executive. That takes us to the next arm of government. I hope you're enjoying the class. Please subscribe more to this channel to get more of this. And don't forget, I said earlier, I'm going to test you by the end of this class. Okay? So we'll go to the third arm of government, judiciary arm. Okay? This body is responsible for interpreting and, of course, explaining the law. Remember, the first organ makes or formulate the laws. The second organs implement or execute the laws. And the third one, judiciary, interpret and what? Explain the laws. So what are the functions of judiciary as arm of government? We have interpret or apply laws, as you see in the definition, settle dispute between individuals. When two individuals are having issues, then they go to judiciary, okay, for settlement. They also settle dispute between individuals and states. An individual could have issue with the states, that is the government. You can sue a government to court, all right? They also settle issues or dispute between the organs of government, either between legislature, most of the time between legislature and executive, and sometimes between a level of government and another level, say federal and state government, or state and local government. All these are functions of judiciary. So as I mentioned in judiciary, it should come to your mind, what am I talking about? The law courts or the court of law, okay? Of course, judiciary protects fundamental human rights, adjudicate criminal matters, review the constitutionality of laws and actions. It is judiciary that will let us know whether a particular law is constitutional, made by legislature, is constitutional or not. It is this judiciary that makes us to know whether the actions of the government, particularly the executive, is lawful or not. Okay? Now, types of judiciary arm of government. Just like I said a while ago, you know, when I talk about judiciary, basically we are talking about the law courts. So there are various law courts. Like in Nigeria, we have the Supreme Court, which is the highest court in Nigeria, headed by what? The Chief Justice of the Federation. Okay? We also have the Federal Court of Appeal, where when you are judged in other courts, other lower courts, and you are not satisfied, you can go and appeal. Okay? That is headed by a president anyway, president of the Court of Appeal. Then we have the Federal High Courts. We have the State High Court. We have the Sharia Court. We have the Magistrate Court. And of course, the lowest court in Nigeria is the customary or local courts. Okay? Now, we're looking at independence of judiciary arm of government. Why must we look at this? It's very essential that we look at this. Very, very important. Why? For security of tenure of the judges, so that judges should not be easily removed, either by the executive or by the legislature. Then for financial and administrative autonomy, they should be independent in their operations. Then for appointment procedure based on merits, not just the president putting whoever he likes in that particular position. And that is why there's always what they call judiciary commission or judiciary council that's made up of retired judges who are experienced in the law, people of impeccable characters. They are the one that suggest who should become what? A judge in the law courts. There should be safeguard freedom from improper political or executive interference. Most of the time, the executive want to have overbearing influence over the judiciary. So we need independence of judiciary to prevent this. So all these things we are putting in place is to ensure there's impartiality, is to ensure there's justice, is to ensure there's fair adjudication and interpretation of law based on the constitution of the state. Okay, now that you have understand the three organs of government, the legislature, the executive, and the judiciary, let us look at the separation of power and checks and balances as it borders on these three organs. What is separation of power? It was a French philosopher in 1748, Baron Charles de Montesquieu, that popularized the ideology or the principle of separation of power. And he is saying that the people that occupy the three organs of government, legislature, executive, and judiciary, should be separated. They should be separated in terms of personnel and functions, such as to prevent arbitrary or abuse of power. In a way to prevent one becoming too powerful, then there should be a form of separation of power, okay, among those who are operating the three organs of government. Remember I said in terms of what? Personnel and functions, all right? In other words, if Mr. A is a member of the legislature, Mr. B can only make law. It's not permitted to be a member of executive or judiciary at the same time. I hope you understand. That is the principle of separation of power as promoted by Montesquieu. All right? Now, let's look at checks and balance. Now, checks and balance is a principle of government that tends to contradict as well as complement separation of power. In other words, if these three organs of government, the legislature, the executive, and judiciary, are working together to make up the government a success, they cannot be totally separated. In other words, there should be a window of opportunity by which they can check one another for balancing the power in government. And that is the essence of this principle of government, that each arm has power that limit or review the powers of the others, so that none of them will become so abusive of the power given to them in governance. Okay? So let me give you a practical example in this. For instance, the special power given to the legislature to check the other organs of government, I mean the executive and judiciary, is known as the Act of Parliament. With this Act of Parliament, the legislature can impeach the president, who is the head of the executive, all right, when it goes contrary to the constitution of the state. Okay? With this same power to Act of Parliament, this legislature can also approve funds that's available to government. In fact, the government, who people think is executive, are not permitted to spend money without the approval from the legislature. So this is a check on the power of the executive. You may not ask, what about the executive? The executive arm of government is given another power under checks and balance, known as what? Veto power. With this veto power, the executive can check the other two organs, I mean legislature and executive and judiciary. Okay? For instance, with the veto power, the executive can withhold assent to a bill. When a bill must have been passed by the legislature, the executive, under veto power, can withhold assent from turning that bill to become law until certain processes are undertaken before the bill can become a law. Also, the executive can also delay in the appointment of governmental officials, because that is within the purview of the executive veto power. You may ask, what about the judiciary? The judiciary arm of government was given a special power under checks and balance, known as what? Judiciary review. With this judiciary review, the judiciary arm of government can declare the actions of the executive arm as illegal or null and void. They can also checkmate all the laws made by the legislature. Are you with me? Now, the law court can issue injunctions against unlawful acts or appointment of the government. Remember, appointment are done by what? By the executive, while the approval or the confirmation are done by who? By legislature. Even when this process are being done, the law court can issue injunctions on this appointment and the confirmations. So this is, in a way, checking the powers of the legislature and the executive. I hope you are following me, okay? Because like I said, I have some questions to test your understanding of this teaching after the end of this class. Very well. Before I round up, before I go to this question session, let's look at rule of law and constitutionalism. What is rule of law? Albert Van Dyce in 1885 wrote about rule of law. And he said that rule of law is a principle that all persons, mind what I said, all persons, including the president, including the prime minister, all persons, including all the organs of government, those that make up these organs, and institutions, that is organs, agencies of government, are subject to and they are accountable under the law. They are all under the law. Being a president or being the head of state or head of government does not make such person to be superior to the Constitution. Everybody is under the law. In other words, there is equality before the law. That is the injunction of rule of law. Okay? And this rule of law goes hand in hand with what we call constitutionalism. What is constitutionalism? Constitutionalism means obedience and adherence to the provision of the Constitution, doing what the Constitution says, operating within the framework of the Constitution. That's what you call constitutionalism. In other words, government must act within the bounds of either the written or unwritten Constitution that defines the powers, protect the rights of citizens, and establish legal limits and procedure for change, either for amendment procedure of the law, supremacy clauses, and the right protection. All these things are composed in the Constitution, and the government is expected to abide by them. Okay, I hope so far you have enjoyed this class. And at this point, I want to test your understanding of this short lecture I've just given to you. With this, I have come to this topical class, the end, right? The end of this topical class. And like I said in the course of the class, that I'm going to examine you to know whether you actually follow me and understand all what I've been teaching you. So please, I will advise that you stay tuned and check on this channel as a video for the questions on this topic is being uploaded.
Hi, I'm sure you enjoyed the content you just watched. To see more episodes as that, preparing you for your oncoming exams, smash the subscribe button on this channel right now and visit the playlist that we've made for you, covering over 50 types of different exams, including JAMB, WAEC, Cacao, NET, IALT, and the likes like that. Also, in every video you watch, we have the link to our apps where you can download on Google Play Store and Apple Play Store and practice hundreds of past questions for free.